Bombshell ruling after bombshell ruling from the Supreme Court on Friday. And most of our viewers probably know about the nationwide injunction ruling, where the Supreme Court held that individuals can't seek nationwide injunctions anymore, but it left open the possibility for nationwide class actions if certain requirements are met, and that states can get nationwide injunctions. That case got a lot of attention because the nationwide injunction at issue was protecting something we all thought was sacrosanct: birthright citizenship. The Supreme Court did not get at the issue of birthright citizenship. Birthright citizenship still exists, to be clear. It's still preserved under the Constitution, despite the Trump regime wanting to get rid of birthright citizenship. A merits based decision hasn't happened. And Harry and I did another take. Groups have already figured out how to get around the Supreme Court ruling, and also states can still get nationwide injunctions based at least on how the Supreme Court phrased that order. But when everyone's focused on that ruling, Harry, this June 27th was the last day where
Right.
opinions were issued before Clarence Thomas goes on his private jets and yachts and gets ferried out to Europe, and Jeff Bezos. I'm being facetious. I don't know that Clarence Thomas has those plans or not, but the whole expose on Clarence Thomas was when the term would end, he would have all these billionaire people would fly him around and blah 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 blah. So and ProPublica did a great story, and that you and I had covered that before. In any event, this is their last day before they go on their vacations and they have their speaking gigs and they do all of that stuff. There were other major decisions
Yeah.
that are arguably significantly more impactful on the day-to-day life of Americans, on civil rights, on everybody's relationship with the Constitution, on states' rights, federal rights. So I don't want those other cases to get overshadowed. So our resident Supreme Court expert from Talking Feds, Harry Littman, who was a top official at the Department of Justice and the former top federal prosecutor in the Western District of Pennsylvania, you followed all of these decisions. Let's talk the other cases, because you and I did a take already on the nationwide injunction. What are these other rulings about, Harry?
Yeah, gladly. And thanks for touting me. But I just want to add that, I clerked for a couple of justices. I've litigated a case up there. So I really have followed it very carefully throughout my career. Okay. There are two cases, one that really perpetuated this very strong trend of the uber conservative, the 6-3. And this was June, and this was the last day in June. So it was pretty definitive, 6-3, 6-3, 6-3, with dissents from the three and reading from the bench and the like. And then there was one that broke new conservative ground that people don't seem to have noticed. So the first one I have in mind is Mahmoud versus Taylor, where you have parents who say for religious reasons, when in the public schools there's a curriculum, as there is, that has any kind of LGBTQ plus content, we don't want our kids even to listen to that. Now, you couldn't say that right about Algebra 2. You couldn't say that about the Civil War, but they are advancing a free exercise clause claim to say actually that their religious rights are violated if they are not given the opportunity to absent themselves. That's the kind of argument that would have never flown 10 years ago. You would have thought about, is there maybe an establishment clause violation with giving special solicitude to religion? But this is a court that's been super solicitous of religious rights, and they do that here. And we saw them doing it in COVID and later. Basically, there's just this very special status for this court of people who are making free exercise claims, and they've come more and more to trump, as it were, the establishment clause claims that used to be this sort of analytic framework. Second, there's a case from out of Texas where Texas passed a law, and it has to do with purveyors of obscene, but also indecent and pornographic material, sexually themed material. And what it said is, producers have to go to a lot of trouble and figure out if a certain percentage of people who are going and accessing your stuff are minors. Okay, and the court says that's okay and upholds it. And Justice Kagan, in dissent, says no. Now, it's really important to understand everybody, Justice Kagan, Aaron said, look, that states have special interest in keeping obscene materials out of the hands of minors. And indeed they do, although as a parent, and other parents here, I'm sure would endorse, can say, good luck to them. It just seems like that train has left the station, as it were. But they do. So the point is whether states can do things for that reason that burden the constitutional rights under the First Amendment, which they have, of adults who want to access this material. Every case where this has come up in the past, the court has applied a strict scrutiny test. Although people often talk about strict in theory, fatal in fact, these were challenges that would sometimes win. But basically, the state would have to show there's no other way to do it, to do our really important interest of keeping things out of from minors' eyes, unless we really restrict adults this way. Here, the court struck a new doctrine and said we're going to apply intermediate scrutiny. And what that means is states don't have to show that there's no way they could have done this without, within some more moderate way that wouldn't have abridged the rights of other of adults who want to access the material. So part of it you could say is about obscene or sexually related speech, but it's broader than that. It's a general doctrine about when can the state use the worries about children or some population to really suppress the constitutional rights. There's no doubt, just as there's no doubt they can keep it from children, there's also no doubt that adults have some rights. And they redrew the balance here, did the court, in a way that I doubt will get that much attention in the first couple rounds of coverage, to basically make it easier for states to do that. States don't have to show that we really have to do it this way. There's a lot more play in the joints. So those were two, doctrinal and in the kind of broad legal trends that this court, which is basically almost always a 6-3 uber conservative lockstep majority, this were two cases where they really made a legal doctrinal impact, as well as the impact of the individual cases on the individual parties.
Harry, I didn't want to interrupt you as you were giving your background, and you said, "Hey, you're very humble." You said, "I worked for a couple of justices." You worked for two. You clerked for two Supreme Court justices, which is incredibly rare to work for one Supreme Court justice. So your insights into the happenings of the Supreme Court are critical, because there's no one who knows more about this stuff than you. So Harry, though, there's a broader and more nefarious plan and how this right-wing Supreme Court does this too, because people may recall when it comes to the free exercise clause and how they've interpreted that to push certain to not just remove. This case is removing things from the curriculum that they don't like, but also then to push things that they do like, which is prayer in school, and the separation of church and state in the First Amendment gives way to the free exercise clause as basic, and this court being supreme. So in the prior term, or maybe it was two or three terms ago, what they did was they took that case involving the football coach. It was a compelling case where the football coach just wanted to pray with the team at halftime, and it was like, and then the school's like, we can't let you do that because we're a public school. And the coach is like, but I got to do it for my football team. And the school's like, can you just do it outside? We're okay. Just don't do it right there.
On the 50-yard line.
Because separation of church and state. So there, the Supreme Court used the free exercise clause, and they picked that case particularly to basically move the needle on strengthening the free exercise clause there. Then the Supreme Court took the case where they kind of invented the facts regarding a photographer that wasn't really a photographer, like in
Right.
Colorado, and claimed that there was a client who was gay, but the client came out and is like, "I'm not gay. I'm not a client of yours. I'm not gay. I don't know what this even is. I'm a straight man. What are you talking? Like what? I never contacted you for a gay wedding. Like what are you talking about? Like that's not what I did." But the Supreme Court then used that case to start moving it in the direction of saying, look, private businesses, under your free exercise clause, states can pass laws forcing you to do equality. Like you can now say, I don't want to have gay clients because my religion and my free exercise says this. So I want to point out that this is part of a line of cases, and they do it surgically, but it's like, what's the expression about boiling the frog in water or something like
Yeah.
that?
No,
You
no,
know,
perfect. Yeah.
before you know it, you're in Handmaid's Tale land, and now all of this is allowed. So people are going to use these rulings and even intermediate scrutiny. You take a case where people go, "Ugh, that content is disgusting. I don't want disgusting content out there." So we're all like, "Why are we fighting for disgusting content?" Well, because now when you change the scrutiny from strict scrutiny to intermediate scrutiny, well, now you start saying, yeah, I don't like that content. I don't like that type of music. And I don't like the way the Democrats are speaking. Oh, and if you speak out against immigrants, that's offensive language. If you say bad things to ICE, so it starts taking you on this path, which is why our First Amendment was the first, number one. I'll give you the final word, Harry.
Yeah, no, so it's really true. I think one of the two or three biggest storylines of the whole Roberts Court over the last 10 years has been this emergence of real robust free exercise claims. The progressives have been able to beat it back only a very little bit. And it seems to me that at least some among the court, we know for sure Alito and Thomas, have taken aboard this notion that I think a lot of religious people have, and yet strike others, and it's partly blue red, it's partly secular religious, as really overstated, but they believe that religious people in this country are the subject of great hostility, and they need to sort of balance that. And and the big tool to do it has been free exercise, but I think it proceeds from just a really dramatically different worldview. It's not, if anything, the use of free exercise you would think is more activist. They're changing the law, but you just have, a solid majority that on these kinds of claims in particular. We saw this with COVID, where states had to make all these special allowances for religious gatherings and the like. This is a court, the majority of which feels that religion needs to be a stronger part of American life, and that religion is discriminated against as opposed to tolerated. I mean, other people look out and see a general and really impressive and kind of beautiful toleration of different faiths. But for sure, there are pockets of people, and they are disproportionately represented on the Supreme Court, that think that religious belief is treated poorly and needs to be really given a boost up under the Constitution's free exercise clause.
Right. So the Supreme Court says that their fear is that religions are being discriminated against, right, because they're prevented from discriminating against people.
That's so true, by the way. It is this paradigm of, right, where it's switched on.
Religious
you must have the right to discriminate, basically.
The religious groups the often right-wing aligned religious groups, we as a religion don't like gay people or don't like this race, and we find it offensive that your secular laws are preventing us from discriminating against these groups.
That's
And
really
and
exactly it. Just dead on. That's right. That's the cake shop cases. I have a religious right to express my disapproval here. Well, there are all these laws that say all these other things you can't, you would never, ever, the court would never let this fly, even if you asserted a religious right to discriminate on the basis of race. But it's also part and parcel. And this, when the story is written, and it's possible it will be, of the potential, I think the big thing that's at risk after Dobbs is gay marriage. And it would be on this basis that you can't, make society accept it. And it would, that the inroad into it would be exactly this, not just religion, but the attitude of religion that, for my money, doesn't really describe America, and that I think only a very small percentage of Americans hold, but that people on the court just think we need to protect them.
and just think about it. Here we are, June 2025,
Yeah,
and rights that we thought were protected from the 1960s and early 1970s are now being viewed as woke. Oh, those
yeah,
1960s,
that's true.
1970s woke people, we in 2025 need to bring it back to Gilead or whatever. Anyway,
At least the
Harry,
1950s. Yeah,
yeah, well, it's something, maybe
yeah,
medieval times. I don't
it's
know.
really true. That's really trenchant on your
Feudalism.
part, I think, Ben. Yeah.
Harry Littman runs the Talking Feds Substack, the Talking Feds YouTube channel, and the Talking Feds podcast. So search all of them wherever you get your content. It's where I get my info. Thanks, Harry.
Thank you, Ben. Have a good weekend.
The truth is more important than ever. Check out our new Truth Over Lies collection at store.midastouch.com. All 100% USA union made.